judges. But the government says when the judiciary is getting its fingers in all other forms of government or branches of government, from decisions of the executive to bills being passed in parliament, then why should the executive and the legislature not have a say in the judges that are being appointed to the highest courts of this land? The NJAC was brought in 2015. It was passed by Parliament by a large majority, but it was struck down by the Supreme Court, saying it is unconstitutional. The question that begs to be asked is, should the judges also relent and accept that there has to be some amount of either executive or parliamentary oversight over who is being appointed as a judge? After all, in the US, in the UK, the executive and the legislature play a role in the appointment of judges. Why should judges behave like the appointment in senior positions, both in high courts as well as in the Supreme Court, is some kind of a turf war? But first, the story so far.
Parliament, in a much-needed historic step, passed the 99th Constitutional Amendment Bill, paving way for the National Judicial Commission. There was unprecedented support. The Lok Sabha unanimously voted in its favor.
Confrontation, which is unfortunately building up, does not augur well for the constitutional scheme, and therefore I had given a notice under Rule 184, an adjournment notice, to have a detailed discussion.
इससे जो कांग्रेस पार्टी और हम में फर्क है ना, कांग्रेस पार्टी जैसा काम करते थे हम वैसे नहीं कर सकते.
All right, this is a full-blown confrontation between the judiciary and the executive. The question is, who will mind the judges? Of course, the judges mind everything, because after all, every law that is passed by Parliament has to stand the test of law, has to stand the test of judicial scrutiny. But what about the appointment of judges? Joining us now on the talking point this evening, Justice B.A. Khan is former Chief Justice of the Jammu and Kashmir High Court. Arima Sundaram will be joining us, Senior Advocate in the Supreme Court. Sanya Talwar is Editor of Law Beat. Adil Singh Bopara is an advocate and spokesperson of the Congress Party. Let me start with you, Justice B.A. Khan. You know, in principle, no one has a problem with the existing system, the collegium system. It has worked well. It has worked well for a number of years. I think the issue is, what the government is asking is, if in every other domain of appointments, from appointments in the government, appointments in the legislature, appointments, of course, even in the Election Commission, which the judges had a few things to say about a few weeks ago, if the judges can weigh in on all of that, why shouldn't government, a popularly elected government, which is the basic principle of democracy, why shouldn't they have a say in judges who are appointed to senior positions either in high courts or in the Supreme Court?
Zaka, but who says is that government doesn't have a hand? They are the movers and shakers. And they start sharing it from the day go. The very stage when the appointment process starts, government shares it somehow or the other, that one knows who goes through that experience. But when you look at it superficially at the highest level, how does one think that government doesn't have a hand? Don't you see that the government sits on the proposals for 6 months, 7 months, and that is the cause for delay of appointments? Don't you see that the collegium recommendations, even if reiterated, are returned? Now, this is not, see, for example, let me tell you the actual process. Actual process is for High Court judge, when a process is initiated, that process goes through government at two levels. It goes through the chief minister, it goes through the governor, then it reaches the central law ministry, and then after that it goes to
Of
the
course.
Supreme Court.
Yeah.
Now, at every stage, you have either interventions or suggestions, or you may call it whatever, maybe by the chief minister or maybe by the governor. And unless it is approved politically, much of it doesn't go through. So to say that the government has no share in appointments is only looking at it superficially.
No, but Justice
inside of
Khan,
it-
my point was, you also agree that these 6 months delay, 7 months delay, maybe sometimes even a year's delay is perhaps caused by the fact that the government it does not, have a say, or not have a say, but the government's choice is not endorsed by the judges, by the collegium, as it were.
That is not true. Practically on ground, in consultations, they share who the candidates are and who should get cleared and who should not get cleared. So those are back channel talks, as you call them. So it's not that. It is happening everywhere, but this is the only problem today is that what I see is that there is a pattern to take away this collegial system from the Supreme Court and appropriate it to the executive.
Okay,
I
to
think that
come
is
up with an
only-
NJAC-like system. But let me ask Arima Sundaram, who's joining us today, what the court said was pretty scathing in its observations, where a bench headed by Justice Sanjay Kishan Kaul basically said that Parliament has the power to enact laws. The government can ask the Parliament to lay down a new law. No one can prohibit it. You want to bring in a new law, gather consensus, you can always do that. However, you may have to then stand the scrutiny of a challenge. The scheme of the Constitution requires the court to be the final arbiter on the position of a law as enacted by Parliament. Now, yes, of course, no one is taking away the rights of the Supreme Court to see if a law that's passed is constitutional or not, or stands the test of judicial scrutiny. But if you have a popularly elected government, and in a democracy, whether you like it or not, that is a reflection of the will of the people. And if the will of the people has passed a law, then should the judiciary have the final say on it, as Justice Kaul may be indicating in the statement that he made?
Well, to say anything contrary to what Justice Kaul said would be to rewrite the entire Constitution of India and the very concept of modern democracy. Let's understand what is modern democracy. Modern democracy has as its very basic fulcrum what is known as the separation of powers. By the separation of powers, you have the executive and the judiciary, and in a case where the legislature is a totally separate body, the legislature, and each has its scope of activity. Now, under our Constitution and under the Constitution of most countries, including the United States of America, which everyone likes to tout about, the American Supreme Court also, well, the fact is that the final arbiter as to whether a law is constitutionally valid or not is the courts. So what Justice Kaul said today is nothing really different than what the law as we know it is, and not only the law as we know it. Starting from 1215 AD in the Magna Carta, the concept of the rule of law. Now, it doesn't mean that just because there is a majority and the majority decides at that given time to do something which is against the Constitution, that the court cannot interfere with it at all. That is not so at all, nor is it the basis of our Constitution. Our Constitution makes the Supreme Court the final arbiter, and in fact goes one step
that's
further,
in the process
which you won't
of
find in any other
lawmaking
constitution,
and
where under Article
adjudicating upon that law.
141, it says
If
that
I
the
may,
law-
Mr. Sundaram, on the question of appointment of judges, if the US Supreme Court, the judges are appointed by the executive, the same thing is followed in the UK and other major democracies around the world, why should a popularly elected executive, a popularly elected government not have a say in the appointment of judges in high courts and in the Supreme Court of this country?
Well, the reason is very simple. When the case of Gupta came up and this whole guidelines was laid down and the law interpreted and the collegium system introduced, there was a feeling that the executive at that time was interfering in the course of justice by cherry-picking, hand-picking judges as per their choice. And perhaps if people were not felt to be more, let me say, more academically or more through policy or belief against what the policy or the belief of the government was, the government of that day, and we're going back to 1994,
Okay.
the government of that day felt that, look, we don't want such a person as a judge. Now, that immediately strikes at the very independence of judiciary. The independence of the judiciary is that a judge is fearless, a judge decides the way he wants, the judge decides the case according to the Constitution.
Absolutely.
And that is the independence of the judiciary.
I don't disagree with you there.
So in which case, if it was felt at that time that the executive was interfering with this course of justice by trying to pack a court, and that was the expression I remember being used in those days, packing a court, superseding judges, superseding the chief justices, it was a situation where it had really got out of hand.
Fair enough. No, I don't disagree with you on that.
While it
Mr.
does
Sundarab,
say
I don't
the
disagree with you
president
on
will
that.
appoint, it doesn't say on whose advice.
Let me ask Sania Talwar though, by that same token, that if you were to give the executive a more than fair share of its say in appointment of judges, then it will lead to, as he said, the packing of pliant judges in high courts and supreme courts. No one is disagreeing with that. But by that same token, Sania Talwar, shouldn't the minutes of the collegium meeting, what was decided as far as the credentials of Judge X or Judge Y, shouldn't that be made public? Because if every decision of the government, a popularly elected government, is held up either in court, has to stand the test of judicial scrutiny, or more importantly, also open now to the Right to Information Act, why shouldn't the minutes of the collegium as to why the collegium of judges oppose the candidature of a certain judge, or why they approve the candidature of a certain judge, should that not be made public for the country to know?
Precisely, Zaka. I think the question that we should be asking today is judicial sovereignty or primacy versus judicial independence. These are two things that we should be focusing on as against each other instead of the executive versus judiciary. Like you rightly pointed out, nowhere in the world are judges pointed out primarily by and only by the judicial members or the judges itself. The entire concept of appointments is just shrouded in mystery, and it's for all the amazing work that the judiciary has done in the country. I think it is very important that the system and the way, the transparency that is expected of a constitutional democracy is also projected in the judiciary. If we are looking at the system as it stands today, no doubt the collegium is something that has already been upheld by the Supreme Court, and that is a system that is nowhere mentioned in the Constitution for that matter. But yeah, of course, nobody is taking away the power of the Supreme Court, like you said, to be the final arbiter of law. The senior designations are always projected. There is a proper streamlined system for it. The concept is made public of who is chosen. Why are in the UPSC for that matter? Let's take that example. There is a certain criteria which is followed. It is made public. Why not the system of appointment of judges then?
Yeah. So Adil Singh Boparai, whether it is the appointment of the CBI director, whether it's the appointment of secretaries to various ministries or the cabinet secretary, all of this is made public, or it's available publicly if a citizen of India chooses to ask through an RTI. And of course, all of these appointments, if there is any aggrieved party, he or she is well within their right to move either the ACC, or they can even move a court of law. Why shouldn't that same principle apply to the appointment of judges?
Well, Zaka, at the outset, the Congress party is deeply dismayed by the ruling dispensation's consistent attempts to browbeat the judiciary. We're deeply dismayed. The judiciary in our country is the bulwark of our constitution. In a system of checks and balances, it is the judiciary which checks the tyranny of any majoritarian government. You may be in a majority, but that doesn't necessarily mean you're right. What is popular is not always right. Let's not lose sight of this fact, number one. Number two, the second misconception which is being circulated by the BJP, that the government has no say in the appointment of judges. Let me tell you, there are IB reports. Those IB reports are carried out, those intelligence checks, background checks are carried out by the executive. Then the Law Ministry can send its inputs. And then there is also a provision where the government can return the names to the collegium. So therefore, this is a misnomer that the government has no say. There have been numerous instances in the past where the government has returned the file with certain notings, and then the collegium reconsiders those notings. It is only on the second round that the government is bound to issue warrants of appointment. So therefore, it is important to just clear these cobwebs.
No,
Number three,
Adil, if I
let's
may,
not move-
Adil, the problem is, as Justice Khan was saying before you joined the show, the problem is the government then sits on these names for 6 months, 8 months, sometimes up to a year, because they don't want to clear these names. Now, would you rather, avoid? Look at the Supreme Court itself right now. In what should be a full strength of, I think, 34, 35, there's a vacancy of 6 or 7. I mean,
So what's that? No, let's test this. Let's test this, Zaka. I'm glad you raised this point because it's a very important issue. Let's test this. For example, tomorrow X name is sent by the Supreme Court Collegium to the government. The government, based on IB reports and otherwise, makes certain notings which are plausible. Where those notings are done based on certain material.
Okay.
And those notings are then, the file is returned back to the collegium. If there is basis to those notings, why would the collegium not reconsider that name? It merely can't be that the government says that it is my way or the highway. If the name is agreeable to me, then I will issue warrants. Otherwise, I will not issue warrants. Yes, this is a problem. The government sitting on files is a problem because that is a manifestation that either you send our names or we will sit over those names no matter the vacancies may rise. So therefore, it is important the government has its say.
So
The point which I'm trying to emphasize is that the government has its say. It can make notings, it can return the file to the Supreme Court Collegium. It is on the second round that they're bound to pay heed and issue warrants. Therefore, let's not lose sight of the fact that we're a government, we're a constitutional framework which is based on the edifice of checks and balances. No one organ can ride roughshod over the other.
So I want to ask then to Justice Khan that at the end of the day, then what value does a popular mandate, not forget about popular mandate, there are laws that have been passed unanimously by Parliament, unanimously across party lines, that have been held up in the Supreme Court. Then what value does unanimity in a democracy have, political consensus in a democracy have?
Zaka, I think distinction first is to be made on two or three things. One is selection process, another is appointment. Selection process, you have to have a selection body for any appointment, for example, as you have in the bureaucracy or as you have in the police, similarly in judiciary. Question is, for ensuring independence of judiciary, there has to be some selection mechanism which is independent of the government so that you don't have an executive interference tomorrow or on day-to-day basis. Now, why it was given to the collegium at that time was in the hope that the collegium comprising of 5 senior judges know better who are the suitable people from the bar, who have the merit, who can be good judges and so on and so forth. Second, that they will act fairly, they will act in transparency, and they will have some criteria to choose. That didn't happen. The result is any system is good or bad as you work it out. Now, those expectations failed, and we had complaints, and we had genuine complaints. Now, those complaints were nepotism also, favoritism also, pick and choose also, all as it is happening elsewhere. This is one. Second, there is a misconception that we have a people's representation and Supreme Court is nullifying a people's will. We are in a system governed by a constitution. That constitution separates 3 kinds of powers, as Mr. Sundaram was explaining it to you. And judiciary has a power of exercising judicial review and strike down any law made by the parliament. Question of the will of the people doesn't come in there. We don't have a mobocracy. Only people will elect everything. Now, people will elect what is permissible under the Constitution. Now, Constitution says Parliament has the right to make a law. It's domain. Who interferes? Supreme Court doesn't make a law. No court makes a law. Supreme Court only interprets that law and sees whether it conforms to the boundaries of the Constitution or it doesn't. Now that's a power given to the Constitution. How can you take that power on the plea that people's will is, as that Law Minister last time said?
On that front, I agree. The interpretation of the law is the remit and the domain of the judiciary. But who gets to interpret the law? Should that be left to the interpreters of the law, or should that be left to people who've been elected by popular will?
Only interpreters of law. Zaka, do you know that in our parliament, what is the percentage of the MPs who participate in the legislation? Do you know how many of them know what law is made? How can you trust a system like that?
Okay.
But
no.
That's not the point.
So,
point is, Parliament has a domain to make law. It falls within its prerogative.
No,
Supreme Court has the jurisdiction to strike down it.
I want to ask specifically on the context, in the context of appointment of judges, Arima Sundaram, the fundamental difference.
In the context of appointment of judges, distinction is lost between a selection process and appointment.
Okay.
Appointment is done by the government, but
fair enough.
For example, if a Public Service Commission, UPSC, that's a selection mechanism. So is the collegium. Now, if UPSC selects a person, a police officer, government appoints him. If there is something wrong with that police officer's record or whatever or suitability, government asks for a reconsideration.
I go back, sir, with your permission, I go back to the example, and I'll ask Arima Sundaram also, the example of the CBI director's appointment. A mechanism was evolved, but I think it's a fair mechanism now, where you have the Prime Minister, you have the Leader of the Opposition, and you have the Chief Justice of the Supreme Court to appoint the CBI director, right? So you have all three branches of government having a stake in who the CBI director is. Now, I want to ask Arima Sundaram, is the fundamental difference in the interpretation between the Supreme Court and the Executive, both on Article 124(2) and 217(1), because under the original provisions, the power of appointment was solely vested with the Executive, in consultation, of course, with judges of the Supreme Court and the High Court. For 40 years, that practice continued. Why is there now a need to relook at that? Because there have been instances of not just nepotism, as Justice Khan said, but there's even been an instance of a judge being sent to jail.
Zaka, let me answer your question on two fronts. Number one, you asked why a system which had prevailed earlier was changed way back in 1994. It was not changed now, it was changed 25 years ago and more. The reason for it, like I said, was, there was supersession of the Chief Justice, not on one occasion, on two occasions. At the emergency time, the kind of things which happened. All that happened. And it was felt that the Executive is interfering too much in the judiciary, and through judicial appointments was therefore interfering in the judiciary, and there was a question of separation of powers. Question was, this consultation with the judges for appointing the judges, is this a consultation they should be bound by? Which brought them to the collegium system. Now, I'm coming to the second issue. I agree with you on one point, on what you said about the CBI director has a widespread representation.
Yeah.
According to me, what went wrong with the NJAC? And what went wrong with the NJAC is, while the NJAC, for example, everybody would have full faith if the Prime Minister of India was part of this collegium which chooses a Supreme Court judge. There would be that if the Leader of the Opposition was, and if a collegium of judges, they were all a total body, in which case there's no question of sending back, sitting on it, they would all be. But the mistake in the NJAC was that they gave the final veto to the Executive. They gave the primacy to the Executive. And according to me, the primacy should have been given to the Chief Justice,
so you're saying,
and not to the Executive.
Can I just
if
clarify
there was
that?
a disagreement,
you're saying
it
that
is,
if the NJAC,
after considering everything, it is the Chief Justice who should have decided.
If the NJAC has equal representation for, let's say, the Prime Minister, the Leader of the Opposition, Supreme Court Chief Justice, and other stakeholders, with primacy, ultimately the veto power, as you said, goes to the Chief Justice, that is something that the courts would consider good in law, acceptable?
I don't know what the courts would consider. I will tell you what I believe.
Okay, of
I
course.
believe if the NJAC believed that if there was a disagreement, the view of the Chief Justice shall prevail. Okay. Not just veto, but also for an appointment. Let us say the judges felt an appointment should go through. The executive felt it ought not to go through for certain reasons. Those reasons are discussed. Why? Because the executive is there and putting forth those reasons. Then it's discussed by everybody, and if a collective decision cannot be arrived at unanimously or even otherwise if there's a split, then the primacy is the Chief Justice of the Supreme Court, who would then decide as to whether it was a yay or a nay.
Let
and
me
that,
ask,
I feel, is a workable solution through representation and may also stop this sitting on files problem which is being found today.
Let me ask Sania Talwar, because there's a history to why the collegium system came into place, whether it was the second judge's verdict or the third judge's verdict. Ultimately, there were instances where government was superseding chief justices of high courts and even sometimes the chief justice of the Supreme Court. Ultimately, the whole idea of having a judiciary as a third pillar was to keep a check on the executive, was to keep a check on political power. Therefore, these judgments came into play, and that's why the collegium system came into existence. So, the chances of the executive misusing its power is far more than it is of judges, because at the end of the day, they have fixed tenures.
See, Zaka, I come from the thought process that when we are looking at any particular provision, it's also ideal that we look at what the constitution makers originally also envisaged. When we are looking at the appointments of judges, and when we are looking at say other appointments, say the senior designations, etc., why is it that when we are designating a senior, we are looking at a full court reference and we are asking the entire court for their designation, but when we are looking at judicial appointments, we are only looking at 3 judges. We are only deciding amongst 3 judges for the high courts. So this transparency, this has to come out. I mean, it has to come on the face of it, because that is what the constitution makers also envisaged. But to say that if one particular part of the constitutional democracy has more veto than the other, it will make a better system. I don't think that is what the constitution makers also envisaged. They wanted a middle ground, and if we can get a better system than what already exists, I think it would be better. Also because the second judge's case literally wrote down the law. So to say that the courts are only interpreting the law is far-fetched.
Okay, we'll leave it at that. I agree with, in principle at least, with one of the things that Sania said, that ultimately you need a better system. I think everyone can agree that the current system may not be exactly 100% right, and therefore if there is a mechanism to have that better system, and Arima Sundaram is right, if the veto power was with the CJI and not with the executive in the appointment of judges, maybe the NJAC would have stood judicial scrutiny. We'll leave it at that. Thank you very much for joining us. The fight for Himachal Pradesh's next Chief Minister is well and truly intensifying. The chorus for Pratibha Singh is growing. The CLP meeting will be held at 7 p.m. A resolution is likely to be passed authorizing the Congress President to elect the next CLP and therefore the next Chief Minister of Himachal Pradesh.
तो मैंने वेलकम किया है, इनका आए हैं हिमाचल प्रदेश में तो इनका स्वागत किया है. कोई ग्रुपिज्म है यहाँ पर कि इतने या मेरे साथ इतना, नथिंग. एवरीबडी इज विद अस एंड एवरीबडी इज फॉर द पार्टी.
This is generally meeting people, and then a meeting has been convened with. MLAs, they are gradually reaching to Simla because people are living in far-flung areas, so they are gradually reaching here. The moment all the MLAs are here, then we will convene a meeting where a resolution will be passed to authorize the party high command. There is no dispute.
The MLAs will take a call, and whatever will be decided will be decided for in the interest of the state. There will be due discussions and deliberations. The MLAs will take a call, and whatever will be decided for in the interest of the state. There will be due discussions and deliberations.
All right, let me go across to Akash, who's joining us live from the Congress office in Shimla. So what really is the hold up? Because Pratibha Singh seems to be the natural contender. Many in the Congress saying that the legacy of Veerbhadra Singh was one of the reasons why the Congress won this election, and she is his widow. What's the hold-up? Who are the other contenders who are throwing a spanner in the works, who are saying that they are more deserving to be CM than her?
So, Zaka, we have a number of names to be, who are in the race as of now, and Sukhwinder Singh Sukhu is one of the stronger candidates, and, he's he is the direct contender, he is the direct competition as of now, and it is visible, quite visible. First of all, I'm showing you these visuals from the Congress office, and Zaka, it is important to mention that this is the 5th time when this meeting has been rescheduled. Initially, it was planned for 12 p.m., then for 1, 2, 3, 4, and now finally at 7 p.m. it is going to happen. Just a few minutes back, we heard Rajiv Shukla saying that there is no dispute, and the aim of this CLP meeting is to just pass one-line resolution where they'll be authorizing party high command to choose one name. However, we know that what is happening in the backdrop. We know that how Pratibha Singh in the morning came out in public and said you cannot forget the name of Veerbhadra Singh, you cannot ignore the family of Veerbhadra Singh. It is somewhere a clear signal that how she is in the race and how she is the top contender. Also talking about, also talking about the other candidates. So as of now, Mr. Sukhu. So Mr. Sukhu is also in the race, and we are learning that Rajiv Shukla is, as of now, meeting Mr. Sukhu at some isolated place. And also after that particular meeting, Mr. Sukhu will also be coming to this particular CLP meeting. This CLP meeting is going to be very, very important, Zaka, because this CLP meeting will somewhere be giving the direction as to who will be the next Chief Minister of Himachal Pradesh.
All right, we'll see how this plays out. It's essentially narrowed down to 2 candidates, Pratibha Singh, the widow of former Chief Minister Veerbhadra Singh, the tall Congress leader who passed away a few years ago and whose larger-than-life legacy continue to have an impact on this poll, and of course Sukhwinder Singh Sukhu, who is considered to be close to the leadership of the Congress party, and whether or not that will have an impact or a say on who the next Chief Minister will be. That's a wrap. Thanks very much for tuning in.
Hello and welcome. I'm Priyatul Siddiqui and you're watching the biggest exclusive tonight. The call for boycott of Pakistani artists and cinema that had started gaining momentum after the Uri attack in September 2016 finally became absolute after the Pulwama attacks in February 2019. The All Indian Cine Workers Association announced a total ban on Pakistani actors and artists in India in the aftermath of this very terror attack. Now, Pakistan soon followed suit and thus stopped the exchange of art and artists between the two neighbouring nations. While many gulped it like a bitter pill, both in India and in Pakistan, many, like Mahira Khan or Fawad Khan, both Pakistani actors, expressed sadness over this decision and over not being able to do films in the country. Because remember, Mahira had just made a debut with the Shah Rukh Khan starrer Raees, and that was her first and last Hindi film. Now, it is these very artists who are the talking point at the moment. Now, this is where we begin today's broadcast, because the film that they star in, The Legend of Maula Jatt, is the film that we're talking about today. The much delayed release in its own home nation in October this year is now set for an India release on December 23rd, if reports are to be believed. Now, this information has got some very volatile reaction by the Maharashtra Navnirman Sena leader Amey Khopkar, who's also, by the way, is a film producer. Now, Khopkar has gone on to threaten to stall the